I'm in Santa Ana today to support a client at a sentencing hearing. The guidelines are 78 to 97 months. The government's asking for 87 months. Let's head upstairs and see what happens. Okay, heading in a moment. Government's asking for 87 months. The probation officer in the probation report asked for 78 months. A couple of things Rob did well, but this is going to be a tough day. There's a bunch of victims here to speak. It's going to be tough. What Rob did well, why am I whispering? There's no one here. What Rob did really well was get his narrative into the probation report. So whether our team does it or you do it on your own, create that narrative, get it into the probation report, because if you're going to use your narrative to influence the sentencing judge, why not use that same narrative to influence the probation officer who's going to recommend how long you should serve in prison? Further, in prison, a case manager can see that you took the time to write this narrative, because that's all they're going to have in federal prison, that the case manager is going to have your probation report. And if and when they go through it, they'll see this narrative, which could articulate your remorse, your shame, your substance abuse, any medical issues and whatnot. So government asking for 87, probation 78, many victims here to speak. I will report back soon. Okay, we have a break. If you've ever listened to our work, we always encourage you to understand the stakeholders. Who are the probation officer, judge, prosecutor? What is their goal? To get a conviction, to advance their career, to get justice for victims. I share this. I ran over here with this little break. I share this because the defense attorney opens by arguing this is our client's only transgression, otherwise led a law-abiding life, wants to get in, get out, and repay all of his victims. All things you would expect a defense attorney to say. Well, let me remind you what Judge Gutierrez told a panel at a sentencing conference in San Diego a couple of months ago. He said, I don't think white-collar defendants, this is the only time they did it. I think it's the only time they got caught. I think it's a pattern. You've got to embrace that, because the U.S. attorney opened up by saying this isn't the only time. He may have no prior criminal activity. However, here's other things that he has done that borders on criminal activity that really debunks this idea that it is an out-of-character transgression. This is really part of his character, and they allude to things that our client said before sentencing, after sentencing. While not criminal, they allude to the fact that this is a pattern and not just a one-time thing. You've got to embrace that. If you think that U.S. attorney is going to get up and defend you and say, yes, Your Honor, this is the only time that he's done this, and otherwise he's led a law-abiding life, like I've said before, you really believe that tobacco companies don't want you to smoke cigarettes. You've got to embrace it. And the only way I think you can do that is by demonstrating through your own words how and why you've learned. Or if you've done other bad things, be authentic, own it. If there's other mistakes you've made that the government clearly has, because they have every email you have ever sent, own it. But don't create a facade that this is the only time if there have been other activities. In this case, I think the judge is a little weary, not quite sure if there were other transgressions or criminal activity, but you can expect the U.S. attorney to sow doubt. It's what they're paid to do. So what we have right now is victims getting ready to speak. There's a little break in the hearing. It's been a very difficult time. One takeaway, and I had to remind our client during this break, it is hard to hear things that the U.S. attorney may say because you don't agree with it. You've got to sit there quietly. Do not shake your head. Judge Carter is upset by U.S. attorneys that or defense attorneys that respond inappropriately, defendants who sit there shaking their head and not agreeing with what's taking place. You can't issue a statement of remorse and shame as the defendant, then sit there and shake your head if you don't agree. Our client only did it once. I reminded him to never do it again, and that's how I'll close before I get back into the hearing. The U.S. attorney opened up by stating the factual things of the case, the fact that, Your Honor, he signed it, Your Honor, he signed it, Your Honor, he signed it. And I know how troubling that is for all of you, because many of you feel you were cajoled or forced to sign a plea agreement that you did not agree with because the risk of going to trial and winning are so incredibly low. So it was really hard for our client to hear the U.S. attorney say, the facts, Your Honor, he signed it, the facts, the facts, the facts. When you're thinking, I had no choice but to sign it. This is what I'm hearing. I'm going to get back into the courtroom. Again, the government's asking for 87 months. It's about to get very emotional when the victims speak. Judge took a break to speak with the probation officer. Update. Judge Boo, in a video on YouTube, told us, as a judge, he wants to hear from the defendant because it's the most powerful to hear from the defendant in their own words. Well, on the flip side, While a U.S. attorney can articulate the consequences to the victims, it is nothing like hearing from the victims. And for the last hour, we heard more than 10 victims speak. In this case, there's more than $3 million in losses, more than 100 victims. What's unique about this case is victims spoke about losing $2,000, $3,000 and the huge impact it had on their life. Then a victim who lost $400,000 spoke, a grandfather in his 80s. And the judge essentially said, this goes over the whole spectrum for $2,000 or $3,000, destroying someone's life, to $400,000 and everything in between. What's making this a very difficult sentencing hearing is the judge reading the communication between the defendant and the victims, and what was articulated to the victims throughout this process, things that were said when these victims were asking for money back, lacking sympathy, continuing to lie, and it continues to speak to this pattern of making bad decisions, and it's very sad, and it's very hard to hear the victims, and it's hard not to empathize with them. Again, the government's asking for 87 months based on what I'm hearing. I think there's a chance he may get remanded. The judge is angry, he's upset, and he continues to tell the victims, it is not your fault. It is not your fault. Judge said, I've had astronauts in here, I've had generals in here, I've had brilliant people in here who have fallen victim to frauds. It is not your fault, and I know you will suffer for this for the rest of your life. And he said repeatedly, I doubt you ever get your money back. Judges frequently say that, though of course people do pay the money back, but a lot don't, of course. So very sad to hear all of these victims speak, and I do believe our client empathizes with them, and I do believe that he's remorseful, though of course some people believe that to be lip service. Next video, the last one, will be the sentence. After the break ended, I saw two marshals sitting in the front row, which was a clear sign to anyone with a brain that as soon as our client was sentenced, he was going to be remanded to custody. The victim statements were incredibly impactful. The judge was disgusted at our client's behavior, spoke at length about the lives he had ruined, from people who lost $2,000 or $3,000 to as much as $400,000. There was debate over money that was paid back. The government said, look, any money that he paid back was simply to further the scheme. It shouldn't be credited towards restitution. That was like more than $600,000 or so. So you could tell that it was going to go bad. My concern as it went on was that he may get more than 10 years in prison. In the end, while the government asked for 87 months, the judge sentenced him to 78 months in federal prison, which was a huge win. Huge, thanks in large part to the probation officer, I believe. I can't believe he didn't get the 87 or 97 months. 78 months was a huge win. Got a recommendation for the drug program, got a recommendation for the satellite camp in Sheridan, because of course in California, no camp has RDAP. And while he was remanded to custody, and while it was very hard for his children and his wife to see that, it brought a lot of pleasure to the victims. Some of them clapped. The upside for our client is at least he gets credit for a day in jail. The clock gets started and get this experience over more quickly. To how much time he'll serve, we're going to do the math. Our team has actually created a calculator that will help you understand good time and RDAP and First Step Back credits. I'll put a link to that calculator to help all of you understand how the First Step Back can influence your time in prison with earned time credits and all that good stuff. So for now, to wrap up, from Santa Ana Federal Court, our client was sentenced to 78 months, 9 months less than the government was asking, and he's in custody. Thank you for watching. Subscribe to learn more about our work and guidance to get through this very difficult experience.